Good morning, good afternoon, or good evening, everyone, and welcome to a webinar hosted by the Object Management Group addressing data residency challenges. Thank you for attending today. My name is Tracy Berardi. I'm Senior Marketing Manager with the Object Management Group, and I'll be moderating the presentation. Data residency is a very timely and pressing topic. I'm joined by my colleagues to discuss what data residency is, why this topic is important, and to review some example scenarios and issues in this space. For background, last year the OMG, a leading technology standards organization, launched a working group to focus on issues in data residency and standards to address those issues. The working group is currently soliciting input from the industry via an RFI, or request for information, and we'll touch on this toward the end of the webinar. If you would like to download the presentation deck from today, there is a link in the chat box in the GoToWebinar toolbar. You can download the PDF and follow along. And also, we'll have time for Q&A at the end of the presentation. If you would like to submit questions, you can use the questions box in the toolbar. So joining me today is Andrew Watson, Technical Director with the OMG, Claude Boudoir, Principal at Sebe IT and Knowledge Management, and Denise Tessier, Regulatory Compliance Project Executive in the Insurance Center of Excellence at IBM. And with that brief introduction, I'll turn it over to you, Andrew. Thank you.
Thanks, Tracy. So just a couple of words from me introducing Object Management Group for those of you who aren't already familiar with us. We're one of the most successful forums for creating open integration standards in the computer industry. We've been going since the late 1980s, 1989, when OMG didn't mean what it currently means for a whole generation of teenagers, but we had the initials before they did, and we're going to carry on using them as our name. Thank you very much. Our work includes middleware platforms for shipping data between different IT systems. We're best known for the DDS and CORBA specifications and the related specifications in that area. And also modeling work. UML and BPMN are both OMG specifications created and promoted and indeed maintained by OMG's members. We also do work on areas like systems assurance and in a number of vertical domains, including finance, healthcare, and a number of others. Organizationally, we're a member-controlled industrial consortium, a not-for-profit organization, and our members include both vendors and users. That's very important because in any particular area, when we create a specification, we need to know that it's something that both tool vendors are happy to build into their products, but is also something that is of use to end users. Our specifications are free, and as Richard Stallman is fond of saying, that's free both in the sense of free speech and in the sense of free beer. Free beer, the specifications are entirely without cost. You can go and download them from our website without incurring any costs. But more importantly, free speech, the specifications are to the greatest extent that we can ensure this free of any kind of IPR, patents, or other intellectual property restrictions that will stop anybody downloading them and implementing them straight away. We have a very good relationship with international standards bodies, including ISO, which republishes many of OMG specifications completely unchanged as ISO specifications. So next slide, please, Tracy. So I mentioned that we have a very broad international membership. This slide is just a representative sample of our members. It doesn't list all of the members. There are at least another couple of hundred that I couldn't obviously fit onto this slide at a typeface that you can read. The intention of the slide is just to show you that we have technology tool vendors and also technology users, including a number of the largest corporations on the planet. And our membership is approximately 50% in North America and about 50% outside North America, maybe 35% in Europe, and the other 15% from the rest of the world. So we definitely have a range of members for whom the issues of data residency are a pressing concern. So I'll sign off there and hand over to Claude for the next few slides.
Thank you, Andrew, and thank you all for attending. So the first thing, of course, as we try to talk about data residency and what we intend to help people with in this area is to have some sort of working definition. It's a concept that has come to the forefront relatively recently, so the definition is not necessarily entirely stable. Our colleague Denise Tessier on this call has a definition at IBM which is extremely close to ours, and we're not going to quibble about the exact words. Since the OMG is seeking inputs through a request for information, as Tracy said, we have used the definition in the request for information itself, and we say that this is the set of issues and practices that are related to the location of data, its movement across geographies and jurisdictions, which may correspond to countries or groupings of countries or sometimes states, individual states or provinces, and the protection of data as it is located in different places against unintended access. And we do clarify the scope because it's clear that this issue has been exacerbated by cloud computing, but it is also present in a number of other areas. And it is also not just, although it may be largely, about personally identifiable information of human data owners. It also concerns the right to move what is considered sovereign data by countries and states, data about their natural resources, for instance, or obviously data about the workings of their governments or their military. It concerns the licensing across borders of sensitive data that contains very specific kinds of intellectual property, such as genomic data, and the distribution of data that is used by law enforcement agencies, especially in the current context of international threats such as terrorism. So if we can have the next slide, Tracy. So I'm going to present to you 4 challenges that are just examples of ways in which data residency has become an issue or has been identified as an issue. It may have been an issue for a while, but it's only now being recognized as a concept that is separate from or distinct from security and privacy, and it is becoming it's elevated to the same level of importance and consideration in terms of risk and measures to be taken as security and privacy. And the first example is migration to the cloud. If you are planning to move what used to be an on-premises solution to the cloud and therefore entrust the data you are the owner of or already the custodian of, it doesn't really belong to you, but you are holding that data, to a third-party provider who is going to put it in the cloud, then you have to ask yourself a certain number of questions. Am I allowed by law or by various regulations, industry regulations, or by my customers or by my government to put my data in the cloud if I am not assured of where it is going to be located? Is it possible that the cloud provider, for various valid reasons such as backup or resiliency or load balancing, is going to move that data to another country in a way that I did not expect and that puts me, the user, in at least a technical violation of a rule or regulation of my country? The regulations may be unclear about that, so I may not know what I can or cannot do. The cloud provider may not tell you in a timely manner where they are going to be putting the data. And there is frankly a number of IT managers and CIOs who are using that fear to reject migration to the cloud and keep their own little domain intact. I've seen personally this example in Mexican government agencies where there is no trace of a specific regulation, but people are still invoking it as a way to reject migration to the cloud. On the other hand, we have examples like a Danish bank that obtained approval from their regulatory authority to move data to the UK, and but that had to go to the top level of the government. So that's one first example. Next slide, please. The second example is genomic data sets, where data needs to be aggregated across various sets in order to perform better data analytics. And on larger sample, there are licensing issues around that, and there the concern of the users or the providers, the health authorities, the data protection authorities of the various countries is that these data sets, which are very complex, very intricate, and can't easily be inspected by non-specialists, may contain or may still contain information that allows what we tend to call the re-identification of the providers of that information. There's also issues of licensing costs, etc., that occur when that data is moved from one country to another. The third example, if we can go to the next slide, is one I'm personally very familiar with, having worked in that industry for many years of my life, is the processing of data regarding petroleum reserves. The picture on this slide shows you a 3D model of an oil reservoir somewhere in the world. Well, in the US and Canada, we're used to companies being private companies that own their data without too much interference from the central government. However, in the rest of the world, oil companies are typically government-owned, or many are. Therefore, the data about the subsurface is considered a national asset, and the government wants to control where that data is located. However, many of these countries do not have the national, the country-based capabilities to process that data, and need to use either large oil companies like Shell and BP and Chevron, etc., or international service companies to process the data and add value to it. Therefore, the data would theoretically, in order to do this efficiently, need to be exported to one of the massive data centers that that provider holds, and there the problem arises, which is that the government may prohibit that. It may also prohibit doing the remote control, which is an increasing practice of the industry, remote control of drilling rigs or of production wells from a monitoring center located in another country. There's been even an attempt by the Brazilian government in particular to say, if you export data, you process it and add value to it, and you re-import it to my country, because of the added value, I'm going to charge you value-added tax on an arbitrarily assessed financial amount of added value, to which I'm going to apply my extortionate value-added tax. And then we're going to go to example 4 in the next slide, which is a well-known issue recently, of course, the issue of law enforcement and the right of agencies to seize the personal communication of users of services that are based internationally. And we know that there is such a case pending right now between a U.S. company and a U.S. law enforcement agency, because a U.S. citizen being suspected of criminal activity under U.S. law has potentially left some evidence of that in social media and email activity, which happens to be stored in the cloud but not in the U.S. And it is stored in a country where the data protection regulations are much stronger than in the United States, and therefore there is the question of which law prevails. You potentially have 4 different countries involved: the provider of the service, the user whose data is being sought, the law enforcement agency, and the country which is hosting the data. And without harmonious legislation and regulation around the world, you can imagine the mess that this can lead us to. So we're going to now move to slide 5, sorry, to the next slide. And I am going to pass the baton to Denise Tessier.
Yes, thank you. So my name is Denise Tessier, and I'm a member of the Financial Services Global Regulatory Compliance Center of Excellence, or the COE, which is a dedicated unit that was created to assist IBM project teams with regulatory compliance issues, specifically for insurance, banks, and financial markets. So my focus really deals with the regulatory impact upon financial services customers that outsource their IT in some fashion. So primarily my work falls in 6 key areas: privacy and data protection, business resiliency, books and records, risk and audit and management, cybersecurity, and vendor management. So my group's responsible for supporting the IBM sales and delivery teams with large projects for financial services companies looking for infrastructure redesign, consolidation of global branch operations, moves to cloud, and managed IT services, which are often done remotely. Many times these projects involve multiple jurisdictions in different regions of the world. Although I do not provide legal advice, I work with the internal teams and legal to help coordinate a regulatory point of view, which can help the design of a system or service plan, as regulations can significantly impact the project. So any of views that I express in this presentation are my own and not general positions of IBM or the OMG, but needless to say, I run into a lot of data residency issues. And what we've been doing is, at IBM, to look at this issue is what I kind of wanted to talk about just for a few minutes to give you an idea of some of the challenges that we're seeing from a practical customer point of view, to reiterate the importance and the challenges that have been talked about so far and the OMG's worked. So on slide 5, we have a definition of residency, and we've defined it as kinds of laws that are trade barriers that seek to impose location-specific conditions on global production, procurement, investment, and data flows. So this definition here is very similar to the OMG's, and what we've been doing is trying to create a project so that we are looking at data regulations not only from a privacy and data protection standpoint, which is one of the major reasons for data residency or localization requirements, but also looking at other reasons or drivers why countries are doing that. Well, each project that we work on is unique, and laws country by country must be looked at for each engagement with a multidisciplinary team, including legal and security. Our research right now is to try to do some more in-depth analysis of different kinds of data residency laws worldwide to find common themes and requirements that need to be addressed in terms of priorities. So our goal has been to centralize related information into a single database or location that can be shared across the company and help promote educational materials for the delivery teams. So some of what I'm going to be talking about in a little bit is related to that. Tracy, can you go to the next slide? So over the past few months, we've been conducting our own high-level survey of the laws of over 50 countries, particularly those that relate to financial services, and we had tried to identify some trends and commonalities for local data laws amongst jurisdictions that would most impact our clients. In our own projects, we were looking specifically for laws and regulations also that go above and beyond privacy or data protection laws and that are geared to protect personal or sensitive information. While privacy and data protection are one primary reason for governments to create restrictions on cross-border data transfers, there are also some more narrow residency laws in the nature of trade barriers that seek to impose location-specific conditions on global production, procurement, investment, and etc. These kinds of residency laws are interesting to review in addition to privacy regulations because they have more strict prohibitions against data flows or special requirements specific to an industry or sector that might be lesser known generally, but could be very important to a particular industry or client and could be a reason to stop production of a new system or stop evolution of a company's growth and development altogether. Many of the laws we reviewed were designed to protect, favor, or stimulate domestic manufacturing industries, service providers, and/or intellectual property providers at the expense of foreign competitors and were competitive in nature, particularly those operating in innovative industries. As an IT services provider, IBM may be a popular target, but we really wanted to be up to speed in advance of any hot-button countries that outright prohibit outsourcing or purchase of assets or equipment from non-local vendors. And this can apply across industries and affect not only service providers and folks that are providing hardware and software, but people that are users, so folks in the energy industries and the like, which would have already been discussed. We found in some cases that data residency laws will be driven by a government desire to increase access to its own citizens' records and information and or exclude other countries from accessing information. So when we look at the types of other residency regulations, they seem to fall into two buckets in addition to privacy and data protection. There's some local IT infrastructure requirements that are designed to force companies to establish local data centers and other infrastructure within the country. And there's a second set of laws that compel companies to keep the data that they collect within the territory of that country. The requirements can also apply to not only core information but backup systems. So if a company wants to, for example, create a business resiliency plan and have a backup server, sometimes that ability is restricted if there's data residency requirements, and it can be quite a challenge. Either of these requirements can be applied at various levels of the government. So you could have laws on a federal level or on a local or municipality level, and that adds to the complexity. On the next slide, we just have some sample country localization rules to highlight the wide variety of regulations relating to the data residency or localization issue. In addition to the laws that have already been adopted or formally enacted, there are also proposals that are in various stages of approval in various countries which need to be tracked. There may also be situations where a requirement is pending formal judicial or government approval and is not yet final, but could be seen by certain regulators or supervisors as a requirement in practice or a desk regulation that is coming, and it's considered to be precedential or best practice in situations where a regulatory approval might be needed to conclude a contract or affect a business transaction. So for example, often in the banking industry, banks might need to give a notice to their banking regulator or the data protection authority that they're moving data for a certain reason, and there are a lot of proposals that are pending that the regulators will take in consideration when they're approving or denying that request, even if it's not 100% final law yet. These are just, I'm not going to read all of the different provisions, but you'll see the wide variety of laws that are out there that could be considered data localization laws. And in some cases, we have a very strict law, such as China, where the law states that data generated within the country must be stored on servers within the country. Very clear, there's no exceptions to that. There's also some new laws in Russia which mandates that personal data must be processed in servers located within the territory. Again, very clear. In other cases, there's countries that have either laws that are sectoral and are more applied on a limited basis, or they may be proposed. Nigeria, for example, is also very strict, where it bans the procurement and use of foreign computers and technical products in public institutions in Nigeria when locally made products are available for use. So that would be an example of situations where the government is putting in data residency laws for an anti-competitive purpose. And the flip side, Norway has proposed a law that stops municipalities only from using cloud services unless the servers are located in country. So that's again more of a protectionist issue where they want both the hardware and the services to be provided in country, but that may also have a goal of providing access to the information by the government, and there can be multiple reasons for these different regulations that all need to be reviewed. Okay, next slide. So trying to conduct business in such an environment with vastly different requirements and regulations across border data transfer is obviously difficult for IBM and for our customers, who must incur both the cost of researching and keeping up with dozens of different laws and regulations for each project, and also the high cost of running duplicate infrastructure systems when otherwise you wouldn't really need to do so. In my own view, data residency restrictions are the most inhibiting factors for companies moving to cloud technology, which would otherwise benefit the company from an operational, security, and risk management standpoint. And of course, higher operational IT expense means that companies might not have as much money available for other business goals, such as shoring up financial stability or encouraging growth and investing in new products and innovation activities. So this slide here lists several international trade organizations that are working on proposals to curb or eliminate data residency restrictions and to actively encourage cross-border data transfer. So one of the things that OMG will be doing is looking at some of the challenges around these and whether or not standards could be set that would help not only these organizations but individual government regulators. It may be that with better standards and an understanding of the technical controls that are around data transfer that
Denise, looks like we've lost you here.
Oh, sorry. So apologies.
That's okay.
All right. So I was just wrapping up by saying that the work that OMG will be doing to look at standards may be able to help these organizations and governments across the world understand that technical controls and technical standards may be the way to go to protect consumer privacy by setting access and security controls that can be used as meeting various governmental goals rather than the strict data residency prohibitions. So I'm going to turn that over to you on the next slide.
All right.
Talk about
so this is
residency roadmap.
Thank you, Denise. This is Claude Baudouin again. So what we're doing at OMG about this was, of course, when I say what we're doing, it means what our members are doing under the umbrella of our organization, is that we started a data residency working group back in June 2015 at one of our quarterly meetings. That one was in Berlin. We had been discussing the issue for a few months between several people, including Andrew Watson and myself and some members. And we formed a working group which has been meeting quarterly since then, according to the OMG work calendar. And the first idea was that we needed to describe the problem. Obviously, we needed to understand the business need, and Denise has done an excellent job of giving us an overview of what happens in especially the financial sector. We had a number of presentations to provide us the list of challenges that I've given to you earlier. And it became very clear that we needed to first listen to the industry, listen to the users, listen to the IT service providers too about what their challenges are. And in order to do that, we have a regular process, which is to issue a request for information. We wrote it in December and issued it in January of this year, so just barely 3 months ago. And that request for information is in progress right now and has a deadline of May 9, which is in slightly less than 4 weeks. So I will, give you a request to participate and influence our work. We are going to consider then the responses we will have received by that deadline at our next meeting, which is in June 2016 in Orlando, Florida, and we're going to continue the work of analyzing the responses among the members of the working group. And the first thing we need to do is, and intend to do, is to feed back the results of the RFI responses to the world, basically. As Andrew posted, our information that we generate, specifications and analyses are all free, as in free speech and free beer. So we will publish a discussion paper probably by the end of 2016. We think that that's feasible and desirable. But meanwhile, we will start determining from these responses what are the areas where it might be appropriate and useful to go towards the formation of standards or specifications that can be used by the industry to tackle the problem. And we can't necessarily tell in advance what those standards are going to be about that is supposed to come out of the RFI. We haven't defined the solution before understanding the problem. We didn't put the cart before the horse. But we will do some work, and there is a very well-established process at OMG that produces technology standards or technology specifications within a period that is fast by the habits of standards organizations, 2 to 3 years typically, and that is initiated by us issuing requests for proposals. So we create a very specific scope definition, and we issue an RFP, and we say, please, members of the OMG, come back to us with a proposed specification to address such and such definition of scope. And we can plan to start this process by the beginning of 2017, which means that we should, if such a standard is appropriate, be able to vote on it in the 2019 timeframe. So let's go to the next slide. The RFI is not very complicated, as is often the case with such documents. It has a fair amount of text that gives the reader context. You know, what is the OMG? Why are we worried about data residency, etc.? What are some references and definitions that need to be considered? And then the meat of the RFI is only in a small number of pages in the middle of the document. And there are 20 questions. The first 9 questions, or actually the first 8 questions, are basically of demographic nature. They ask who you are, what sector do you work on. We basically try to understand when we read your response, what was your perspective and what was the reason why you were worried about data residency, and about residency of what kind of data and in which countries. And how are you organized to handle data residency? Is it something that is under the control of a specific chief data officer, your risk manager, your your legal counsel, your CISO, etc. That'll give us some insight about who to talk to in the future when we progress the work. And we have a question 9, which is relatively unusual for us, but that we put in there because given the sensitive nature of this issue, especially for organizations that deal with the government, we wanted people to be free to share with us their input without necessarily revealing to the rest of the world their names. So upon request, this will not be the default mode of publication, but upon request, we will anonymize the responses before we publish those responses on the OMG server. And all the responses due to our open process will be published, but we will withhold the name when we are requested to do so. And if we go to the next slide, you're going to see questions number 10 to 20, which are the substantial questions that we're asking people. What is your definition of data residency? We want to detect if that definition includes or excludes things that we had been considering, whether that's a stable organizational definition or whether you just made it up. It's fine to make it up, but we'd rather know. And then questions about what is the risk level that you consider to be present in your organization due to these issues. Can you give us examples of what kinds of data are considered to be at risk in that respect in your industry or your organization? Whether you see this going forward to as being increasingly worse or better or what? What are the regulations that affect you in your industry, in your business, and that you're aware of? Example of known incidents. We have some examples, of course, that we know, and some of them you can just Google them, but it is always very interesting to analyze what caused a conflict between a company and a regulatory authority, for instance, or between a company and its client. And question 16, frankly, is one of the reasons why we put question 9 about anonymity, because we didn't want people to refrain from answering question 16 if they didn't want their name to be published related to that incident. But it could be something that you know about, that you think is very relevant, that we might not be aware of, and that is absolutely not something that puts you in the spotlight, but we'd still like the respondents to provide that information. And then we're asking the respondents, in which areas do you think the OMG should work to help? So what are the areas of standardization? What are the types of publications we ought to work on in order to help the industry resolve these issues? What standards by non-OMG organizations should we consider? Of course, we're aware of ISO standards, but there may be other standards by various industry bodies that we don't know about. There's obviously a number of international bodies about insurance, finances, life sciences, etc., that may have their own standards, and we should look at them. And then 2 final catch-all questions, which are email us any relevant documents and provide any URLs and references to things related to this area. So we're hoping that with these 20 questions we're going to accumulate a wealth of information. We already have a not insignificant number of companies that are working on their responses or are committed to give us a response by the deadline. It is not a huge amount of work to fill this, and this will be really critical to move the work forward. So let's go to the next slide. So, and that is the last slide of this presentation, because we wanted to be able to leave enough time for Q&A. So in summary, data residency has now surfaced as a serious challenge for suppliers as well as users. And when I say suppliers, I mean both suppliers of data or suppliers sometimes of the goods about which the data has constraints, as well as users of that data. And these challenges, the restrictions, as well as the complexity of the web of international restrictions that Denise showed to you, is an obstacle to doing business, and can become an absolute nightmare for companies trying to navigate these regulations, expand their business internationally, function in that context without, falling in the trap of some unknown regulation somewhere that they unwittingly violated. And because of certain discussions, because of the way the issue has been exacerbated by the practice of certain security agencies in certain countries trying to access data, etc., the situation may get worse before it gets better. The current lingering discussion between the European Union and the United States about the data protection shield, which is not yet resolved, it means that the situation may get worse before it gets better. So all organizations, whether they're suppliers, users, consultants, etc., need to learn about this and need to develop approaches to deal with data residency. And some of these approaches are business ones. They relate to business strategy, risk compliance, and risk analysis and risk management, legal compliance, etc. Some of them are going to be technical approaches, how to place the data and restrict its movement in order to avoid becoming an unwitting violator of a regulation. And OMG is looking into what standards may help. Again, we are not prejudging which standards this may lead to, but one possible area is to standardize the metadata that describes the constraints that a certain data set has or carries about where it could or couldn't be located. So there might be self-describing data sets with a data residency sensitivity tag or marker attached to the data set in the form of metadata that could be examined as the data is moved around to say, oops, don't move that data there because it has the following limits to what you can do with it. And the data residency laws and regulations, of course, are all couched in complex governmental bureaucratic language. And another possible standard is a formal, unambiguous representation of what those laws and regulations say, essentially having a common language to abstract all the laws and regulations and be able to analyze them. But again, these are just two of the directions we have thought about in our discussions, and we will add or remove from this as we consider the responses to the RFI, which leads me to my call to action. If you are interested not only in this webinar but also in helping shape the future of how the world addresses this, I would invite you to look at the link here. Sorry that it's a little complicated, but you can download the slides as Tracy mentioned earlier and click on the link. Or frankly, if you just Google OMG Data Residency RFI, you will find it, probably at the top of the page. And that's probably actually the easiest way to get to that RFI. Download it, answer it, come and participate in our working group if you have the time and the interest. The next time we will meet is the 3rd or 4th week of June in Orlando, and then in September in Chicago. The OMG event calendar is on the OMG front page at www.omg.org, and even if you're not yet a member of the OMG, we can invite you to come and give us a presentation or participate in our work. And with that, I'm going to turn things back over to Tracy Berardi, who is going to moderate the Q&A period.
Thank you, Claude, and thank you, Denise and Andrew. Very good presentation. We do have a few questions. First question, are the standards that we'll work on, are they to be based on a United States perspective?
Tracy, I can perhaps jump in there. This is Andrew Watson. Absolutely not. OMG is an international organization. As I mentioned at the beginning of the presentation, approximately 50% of our members are from North America, and approximately 50% of our members are from outside North America. So no, we will absolutely be taking an international perspective on this rather than one that is specific to the needs of any one particular country. The problem, to some extent, arises in different modes, in different ways, for people who are residents in different countries, as Denise's presentation captured very well. If you're in different countries, you know, data residency requirements have different shapes. So I suspect we will have to come up with a framework for handling data residency problems in general, which can then be parameterized for the needs of users and vendors who are in a particular country. But we will not be baking the requirements of any particular country into the core standards.
Thank you, Andrew. And this next question is another good one for you and also Claude. Are there other OMG projects or standards that are thought to be relevant so far to this effort?
I'll take that one, yes. There is, in particular, in the Systems Assurance Task Force of the OMG, ongoing work which will probably near completion or reach completion at the end of this year on threats and risk, and some definition of a standard meta model of threats and risk. And it's clear that data residency, privacy, and security represent operational risks to company, meaning risks that can actually concretely prevent them from operating. So that work is ongoing. There has been some work over the years in the command and control arena about tagging and labeling of data for security, etc. So there is some other work going on in those areas. Andrew, you may think of other things. So I think the upshot is that if you have an interest in in various of these areas, you will certainly find within the OMG some fertile ground to come and work on defining the scope and the solutions to some of these problems, not just in the data residency working group, but in other task forces too.
And thanks, Claude. And yes, I would just add to that. We've done work on regulatory compliance in OMG over the years. This is a very specialized form of regulatory compliance. And we also are, we would claim, one of the international leaders in the area of meta-modeling. Many of the modeling standards that OMG has published are based on a common meta-modeling framework. So if it turns out that the work, the data residency work, moves in the direction of specifying metadata for data residency, I don't think there's anybody anywhere who's better equipped for producing metadata-based specifications than OMG is.
Thank you. And here's a question that may be good for Denise, if you would like. The question is, what if the vendor that a company wants to use for outsourcing, managed services, or cloud storage doesn't have a data center in the local jurisdiction or another allowed political geography? Are there alternatives?
Thanks, Tracy. Yeah, that's something that the OMG is going to be really instrumental in helping us develop. Right now there are some encryptions that will allow data to be submitted, transported safely. So regulators may grant an exception to certain data protection laws for transfer if the data is not recognizable or accessible in the remote country, because sometimes, for example, your vendor may need to just do a backup or look at systems, but they don't want the personal data. So, you know, looking at the metadata, looking at the standards around the transfer and what can be done to protect access and ensure that the information transferred is either scrambled or anonymized will be super helpful. So that's something that we're hoping that the survey project will really help with.
Thank you. And here's a question that relates to the U.S. Patriot Act, asking if we could speak to, why other governments are so concerned about the U.S. Patriot Act.
Yeah, and that's one of the reasons why a lot of the governments are now looking at data residency laws and putting in some protections. For example, Canada has been really vocal about the fact that it would like to keep data in country because if it's sent to the United States, then there's a fear that the U.S. government will have access to its citizens' personal information. So the Patriot Act was enacted after 9/11 as an anti-terrorism response. And it applies to everybody living and visiting the country, including foreign nationals who spend time in the U.S. And it also applies to U.S. companies, whether or not they're headquartered here or just do business here, or a subsidiary of an international company. So under the Act, personal information about individuals and the data that's housed in the U.S. Is vulnerable to interception by U.S. authorities if they suspect some wrongdoing. So one of the more controversial elements to the Patriot Act is the provision that made available to the U.S. law enforcement agencies the demand to hand over stored records and data without a court order, and in some cases without a individual being told that their information is being produced. So other countries that have stricter data protection laws may think that this is a threat to their citizens' information. And one of the things that perhaps technical standards can help with is, a review of personal data that's somehow anonymized or that may be reviewed in camera with only certain very limited access controls and disclosure provided to other individuals. So it's something that is still a very active issue, even years and years after the Patriot Act has been put in place.
And this is Andrew Watson. If I could just add a short rider to that, I agree completely with everything that Denise has said. And incidentally, looking at US legislation, it's not just the Patriot Act that some non-US countries are concerned about. There are also things like the Pfizer Amendments Act. But the point that I would like to make is that we're not making any value judgments here. The laws that exist are the laws that IT suppliers and IT users must comply with. By all means, if you don't agree with the laws, then go and lobby your parliament or whatever it is in your own jurisdiction to get them changed. But here in OMG, we are aiming to help people who must comply with the existing laws. We make no judgment as to why those laws were made. And as Claude mentioned, you have regulatory conflict at the moment. There are occasions where an organization that's based in country A but controls data stored in country B may find itself caught in a cleft stick, forced or with regulators in two different countries trying to simultaneously make it comply with conflicting regulations. And if it complies with one sort of regulations, it breaks the laws in the other country and vice versa. So these are the kinds of situations that we would aim to help companies identify and avoid getting into, rather than, as I say, making any judgments about whether the laws that they are being forced to comply with have any merit. That's not our bag. Go to the lawyers for that.
Yeah, great point, because it is what it is right now, and it's not that you're necessarily going to change the laws, but if you can change the protection and increase the education about the issues and look at the various difficult challenges that are around it, it'll certainly be helping everybody.
Yes, good points. Another question that just came in, is data residency basically the same thing as data protection or privacy? Are we using a new name for what seems to be the same concept? If we could discuss that.
I'll take that one. This is Claude. It's broader. So basically, you could consider data protection to be a subset of data residency. It's a bit more, or I would say maybe I would draw a Venn diagram with two intersecting circles. An example of a data protection issue that is not a data residency issue is if I'm, let's say, a hospital in the United States and I collect data about my patients when they come in and they fill those awful paper forms that we still have in this country, and that data is placed in a computer system to hold the health records of the patients of the hospital. Data protection has to do, for example, with is anyone going to have access to what particular disease I have who shouldn't have access to that data because the hospital didn't take the proper care according to the Health Insurance Protection, Portability and Accountability Act, whatever, HIPAA, to protect that data and prevent it from falling into the wrong hands. This is not a residency issue in terms of jurisdiction and country. We don't want the data collected in by me about me in Austin, Texas, to fall into the hand of my insurance company, which is also in Texas. So that's data protection, but that's not data residency. When we talk about the oil reserves of Malaysia, which by law data about oil in Malaysia must stay in Malaysia, this is a data residency issue. It's not a data protection issue because when we talk about data protection, we talk about privacy of individuals. And here where the data does not describe individuals, it describes the subsurface of the country. So there is an intersection. Of course, you know, if my Facebook conversations are stored on a server in Ireland as opposed to a server in the US, that becomes both a data protection issue and a residency issue, but the two domains are overlapping but distinct.
Thank you, Claude. And if no one else wants to chime in there, we can continue. We have a few more minutes. Next question, are there other organizations working on this subject, and are there any ISO standards that already start to address this?
So
Well,
Andrew,
this is Andrew.
yeah, go ahead.
Yes, on the first one, other organizations. Not that we found talking about the general issue so far. We have bumped into a few organizations that are looking at data residency issues in their particular vertical domain, healthcare or finance or whatever, but we haven't yet found anybody who's looking at the broad data residency issue across all domains. As a colleague of mine at OMG is very fond of saying, there are very few unique problems. There are only unique solutions. There is a risk that people who are focusing on data residency as it applies to, say, healthcare, will think that it's only a healthcare problem. Understandable if your bread and butter is healthcare. The opportunity that we have in OMG here is to take a broader perspective and try to find what are the common themes about data residency and complying with data residency regulations that span all organizational areas. But once again, as Claude mentioned, I mean, we don't claim to be the complete experts. The reason why we publish the RFI is to learn from responders. So if anybody out there, if anybody listening to this call does know of other organizations that are looking at data residency in the round, do please submit an RFI response and tell us all about them.
Thank you. And we'll take one more. This is actually the last question, so we timed this very well. Should, and also then, how can companies support efforts to abolish data localization rules? So should companies do that? And then if so, what are some steps that you would suggest to help abolish data localization rules?
Can I take that? This is Andrew again. As I said earlier, that's really not our, that doesn't fall into our purview. We accept the data regulations as governments have made them, and we are looking to help people comply with them. I can completely understand that complying with some of these data residency regulations, particularly some of the ones that Denise outlined earlier, which seem to have been designed to be anti-competitive, I can understand why companies or individuals would want to lobby their governments to get those laws abolished. But that's not what we're talking about here. What we're talking about here is how to comply with the laws as they stand today. So I'm afraid we can't really offer any advice on how you should engage with the political process to get your laws changed. That's between you and your legislators.
Yeah, I think this is the right answer. I would have said, okay, certainly this is not something that OMG is going to work on. Again, we're not interfering with governments and legislators, but depending which industry you are in, you probably have some sort of industry association which routinely looks at what are the interests of that industry in terms of its ability to do business. So I would refer people with this concern to go back to their trade organizations, their industry associations, etc., and look at working within that context to, at minimum, educate legislators. I think that's the first thing you need to do through those associations. OMG is going to try to find a solution that will be largely a technical solution plus some education material, but we're not going to interfere or place ourselves on the slippery slope of lobbying ourselves.
Denise, did you have any thoughts you'd like to add?
No, I think that's right. It's one of those things that you have to deal with what's given to you, and I think having the technical standards and having the technology education available if there are questions is going to be the real key to moving a lot of this forward, particularly when it comes to data residency that's based on privacy and data protection, because a lot of the concerns are that you can see data in another country. If we can find ways to help that problem, put more controls around it, I think that's going to be a win-win for everybody.
Thank you. It looks like we're here at about noon Eastern time. Great timing again, and I'd like to thank everyone for attending, and thank you very much, Denise, Claude, Andrew. And everyone on the call, you are very welcome to complete the RFI. We would appreciate it. As Claude said, you could Google OMG Data Residency RFI, or the direct URL is here in the presentation slides. A link to the presentation is in the chat box. We'll also post it on the OMG website. And with that, I hope you have a great rest of the day. Thank you so much. Bye.
Thank you.
Thanks, everyone.